Okay. So as Chad said, my area of specialty is estate planning and elder law and disability planning. That's all that I do. So our firm is the Pika Daily Pope and Perry. We have offices throughout the state, but I'm focused primarily in Madison. So that's our closest to you all. So tonight's presentation is going to be about various aspects of estate planning. So we're going to talk about wills, trusts, when you might want one or the other. We'll also talk about ancillary documents, and that includes power of attorney and healthcare directives. I also want to talk to you a little bit about beneficiary designations and how that all fits in with the plan. So what I will do is I will stop periodically for questions throughout the presentation. So we'll try to, because it's a fairly big group, so we'll try to do it like that. And there'll be plenty of time for questions at the end as well. Okay, so the first thing I wanted to just talk to you about, which is something that can be overlooked. So I have clients who come in and they oftentimes will have some sort of a will, maybe a trust, but they don't have a power of attorney because the focus is really on, what happens after you die. So I wanted to talk to you a little bit about a power of attorney and the importance of it. So this is a document that you want to make sure you have during your lifetime. In the document, you're authorizing somebody to manage your financial and everyday affairs during your lifetime. So these includes things like going to the bank, dealing with your real estate, but it also is kind of your everyday things like getting your mail, perhaps checking email or having access to email, contacting Comcast. So I've heard stories where a husband's name is on the Comcast account and the wife calls about the bill and they won't talk to her because her name's on the bill. So things like that, things that you sort of just assume that, they would talk to spouse is not going to happen. Because in fact, just because you are married, that doesn't legally give you the right to have access to someone's information. So being able to speak to, if your spouse has a bank account in his or her name, or retirement account, the institution is not going to necessarily, in most cases, speak to you just because you're the spouse. Because in some cases, the spouse may actually not want them to speak to you, right? So, and their financial institutions are very careful about protecting themselves too. So a couple of technical things. The person who you're appointing is called your agent or your attorney in fact. And when you execute a power of attorney document, the way that the agent accepts their role is through action. So you can name someone in this document, but they have no affirmative duty to actually do anything. But once they start acting, then they have certain fiduciary responsibilities, like acting in your best interest. Also, the agent doesn't have to sign it. So sometimes people say, well, if I sign this document, does my agent have to also sign it? Nope, you just sign it yourself and that makes a valid power of attorney. So there's two different types of power of attorney. One is a general power, and that is one that's effective upon signing. So you sign a power of attorney that names spouse as your agent. It is effective upon signing. Your spouse technically can act on your behalf. The other type is called a springing power. And in some cases, people are more comfortable with this type. And what it says is that you're giving someone this power to act on your behalf, but only if you're incapable of acting for yourself. So that's called a springing power. And sometimes I find that if someone doesn't have a close relative, a spouse or children that they are comfortable naming, they're more comfortable and they're capable, they're fully capable, that they prefer this type of springing power. So along those lines, why is it important to have one, even if you're young and or healthy? Because you don't need help, right? Well, the reason is, number one, like I said, spouse cannot legally act for you. So a lot of people think that that's the case. And then number two is that if you become incapacitated, at that point, then it's too late to execute a power of attorney, because you won't have the capacity just to understand the document and to sign it. So I have cases where someone's children come in to talk about their parents, and they don't have, the parents never did a power of attorney. So if we want to do some strategies to help them, particularly if we're talking about asset protection or getting them on Medicaid, the first thing we have to do is we have to file a petition in the probate court to have the person conserved. And that means that the court has to find that they're incapable of acting for themselves, and they have to appoint the son or daughter or whomever is petitioning in order for that person to have legal authority to act for them. And so when you're in a crisis situation, having to take this additional step can be, adds a lot of extra stress and extra work. So the other thing is that sometimes, people say, well, what if I decide I don't want this person? I've named them, but then years go by and I decide not to. Well, this is a document that can always be revoked and changed. So that's not a reason not to do it, because if something happens with your relationship with that person who you thought you had, once thought would be a good candidate, you can always change it. Okay. So a couple things. So what can an agent under power of attorney do? Typical things are assisting with banking and investments, accessing safe deposit boxes, working with the DMV, working with Social Security, basically filing taxes. I mean, almost anything you essentially can do for yourself. With that being said, the power of attorney document can be written very broadly, or, there might be some powers that you're not comfortable in including. So they can be crafted for what your particular situation is. For those of you who may have power of attorneys in place, you should know that in 2016, the laws changed, which doesn't necessarily make your documents invalid, but they added some things, some important features to the power of attorney, such as making it a durable power, which means that it's still valid even if you later, after creating it, become incompetent or disabled. There are some provisions that make it more difficult for financial institutions to reject them. So what was happening is people were encountering situations with financial institutions where they were saying things like, this is too old, or thank you very much, we'll have our legal department look at it, but it's not on our power of attorney form, so we're not going to accept it. So things like that were happening, and there was some pressure on the legislature to try to make things a little bit more friendly for the consumer. It also allowed people to appoint a successor agent, which I recommend. So it's always good to name a primary person, but then to be thinking ahead, well, what if that spouse, if that person, including spouse, can't do it, who is the next person in line? It added some provisions for accountability for someone who abuses the power of attorney, abuses their fiduciary responsibilities. They can be personally liable. And it also includes provisions where you can give someone authority over digital assets, because that's a reality now. Things like email accounts or online accounts, things like that. It also includes certain things which are called hot powers. So hot powers are powers that your document has to specifically state in order to give someone the authority to do. So these are things where I most see these happening is in the area of Medicaid and long-term care planning. So for example, gifting or transferring assets. So if we're trying to get someone on Medicaid and they've got too much assets and we need to transfer them over to spouse or to someone else, if that person is incapable of executing that transfer, we need someone else to be able to do it. And the law says that there are certain powers where you have to affirmatively state them and sign off on them in the document. because they're significant powers. So things like being able to amend trusts, make gifts, to change beneficiary designations, those are the hot powers that the new power of attorney document includes. So it seems very broad, which it is, but there are certain things that the power of attorney can't do. So your agent can't change or invalidate your will. They can't change your beneficiaries. They can't make decisions on your behalf after death. So sometimes people will say, well, you know, they'll be coming in because a relative died, and they'll say, well, I'm just going to do this as their power of attorney. When somebody dies, the power of attorney is no longer. It's because you can't technically act on that person's behalf anymore because they're no longer living. So that power does not exist. Everything at that point would move over to the estate. And if you have an executor, that person would be legally in charge. So a couple of practical things just to leave you with on this topic is it's always a good idea to name a backup. Even if you can't, you know, the person who you're naming in first in line is healthy and you can't imagine them not being able to do it. You know, there are also cases where people are capable of doing it, but they may decline. You know, they may have things going on in their own lives and they may say, I can't take this on. So you want to have someone else named as a backup. You want to make sure you review, if you have a power of attorney, review it and make sure it has those powers that you might need in case you need long-term care and need to apply for Medicaid at some point. And the other thing too is sometimes I recommend to clients that they, you know, give it to their financial institutions now. So let their financial institution know who their power of attorney is so that they can note it in the file. So if someone does need to come and act for them, what's going to happen is the bank is going to take the document, they're going to give it to their legal department. Legal department's going to have to review it. So it's a process. So again, when it's a crisis situation, it can be just add a lot of extra stress to do it at that time. Okay, so I'm going to move on to healthcare decision-making. Any questions on, yes?
What energizes a springboard action?
Oh, good question. So the question was, with the springing power, what kind of gets it into place? And so that can be drafted in different ways. So you can require, sometimes it can just be that the agent has to produce something in writing. So that would be kind of the most lenient. Or you could say that there has to be a physician who has evaluated the person and has declared them to be unable to act. So you can make it sort of as strict or lenient as you want. And that's actually one of the downsides, is that if it isn't a crisis situation and this person has to jump through all these hoops, you know, that's sort of the downside of that option. Yes.
I have many children.
Mm-hmm.
And what do you feel about having like two of them on power of attorney, and that they can act independently or together? Or is that a problem?
No, so I see that a lot, and I think that practically speaking, oh, yes, I'm sorry. So somebody, she asked what my thoughts were on naming more than one person to be your agent under, multiple agents, and saying that they can act either jointly or what's called separately. And so I see this a lot, and there's a lot of times practical reasons for doing it. You know, sometimes people say, I don't want to put this all on one child, or maybe I have a child who is particularly financially savvy, but he doesn't live here. He lives in California. So it's, you know, it would be too difficult because then I have all this other stuff that this person, my other child's going to need to do. So there's a lot of good reasons to do it. And it really comes down to, you know, you have to be very confident and trust in the people you are naming. And it's a good idea that they get along. So I'll always ask clients, what's the dynamic like? Do they work well together? Because if they're gonna, you know, if they don't, then it's just gonna probably end up being a battle and they're not gonna get anything done. So,
thank you.
Welcome. Okay, yes.
I moved here from California a little over a year ago.
Mhm.
My sister and I wanted to live here until she turned grandma. And then a few months ago, she decided to move to Florida because I was off.
Mhm.
And she said, well, you can follow me, you can come to Florida. And I want to move to Florida. I'll stay here. So now I'm here. Don't know anything. I have no relatives nearby.
Mhm.
I have no emergency contacts. I don't know if I could ask to be a power of attorney. Are there any kind of organizations or businesses that will, you know, you can hire a grandparent?
Yeah, so there are some organizations. I've dealt with one for someone who they do legal guardian, you know, they'll be someone's legal guardian, they'll be someone's power of attorney. So there are organizations that will do it for a fee. I have clients who, you know, will ask me to do it if they don't have, and it's not typically something that I will offer to do because it's difficult if the person doesn't really know you. Because like I said, it's like sort of the day-to-day things, but I have done it for clients if they don't have anyone else. You know, sometimes if you have a relationship with an accountant, or, I mean, it really can be anyone, it just has to be someone that you feel is gonna really look out for your best interest. But it's, yeah, it can be tricky, right? Yeah, yeah, it can be tricky. So, and in that case, you might want to just do a short form, you know, a very basic one if you find someone to act for you, just so that the basics are covered, you know. Okay. So the next, oh gosh. Okay, next topic is, it's similar, but this deals with healthcare making decisions. So living wills and healthcare directives. So the advanced healthcare directives is the document where you appoint someone to make healthcare decisions in the event you can't make them for yourself. So this isn't like the power of attorney where it's springing or general, because most people, if they're capable of making their own healthcare decisions, are going to want to be the one to do it. So in this document, the person you're naming is called the healthcare representative. And similar to the power of attorney, if you do not have one of these in place and you become incapacitated, what will happen is that, again, the person, you'll have to be conserved by the court. So someone have to petition to have you conserved in order to have someone named to be able to make these decisions for you. So not a good situation to be in a healthcare emergency situation. With these documents, so the law did change in 2006. So it used to be called the healthcare power of attorney. Now it's called the healthcare directive. It brought in the powers of the healthcare representative. So instead of just end of life, it allows your healthcare representative to make treatment decisions and medical decisions on your behalf. So if something happens and the doctor wants to treat it, you know, and there might be multiple ways to treat what's happening, they're going to need consent from someone. And if you can't do it, then it will have to be someone with legal authority. It includes end-of-life decision-making, and it also addresses HIPAA. So you can name people who you'd like to receive and your healthcare information and communicate with your doctor. The living will can be a standalone document or can be in the healthcare directive. And that's where you can say that you don't want to make, you know, in the instance where you're in a permanent vegetative state or you have a terminal illness that will likely result in imminent death, that you don't want to be kept alive indefinitely through different artificial means. So artificial respiration, hydration, CPR, those types of things. And you can customize it. So if I've had clients who have said, who have said, well, I would like to receive this, but I don't want to receive this. So the document should really reflect what your wishes are and can be customized for that purpose. So the healthcare representative makes healthcare decisions if you can't make them for yourself and can accept or refuse treatment. Healthcare rep can't do, they cannot make medical decisions if you have the ability to make them for yourself. So if you have the capacity to make informed consent, then you're the one who should be making these decisions for yourself. So a couple of things just to point out is your healthcare representative should be making healthcare decisions based on your wishes. So based on what you would have wanted for yourself. So this is it's an important distinction. So it's not that they should not be making decisions based on what they think is in your best interest. So the question then becomes, well, how will they know? How are they going to know what your wishes are? And that's when I really emphasize to clients the importance of communication. So we prepare the legal document. We prepare the document that says that this person can legally act. But you need to tell them what your wishes are. And there are organizations, there are templates available online. There's one called Your Wishes that I have at the office. I meant to bring one, but you can find it online, where it will address various different topics, end of life topics, and you can write in there what you would want for yourself. So communication is really important. When you execute these documents, you want to make sure you give a copy to your doctor. Everything is electronic now, so they can store it in your electronic records. And a lot of times now I'm hearing from clients that the doctors and hospitals are asking for them.
They do.
Yeah, they want, because they don't want to be in a situation where they are stuck. Yeah.
I didn't get the name of the template that we could look
It's
up.
called Your Wishes. Yep. Okay. So I want to just make this distinction because I get a lot of questions about this from clients. When I bring up a living will and I explain it and they say, well, oh, you mean a DNR? And a DNR is similar but different. So it addresses the similar case of what you want, what measures you want taken. But a DNR is, it's a directive that you don't want to receive CPR if you stop breathing. So, and I think of this more as a situation where someone's responding to an emergency. So you're ill and you say, I don't want to be resuscitated. Whereas the living will is part of the advanced directives. And this is where you're kind of saying, in the future, if I were to ever be in a permanent vegetative state as determined by two physicians, that I don't want to be kept alive with artificial means. So I think of that as more like down the road. So you're in a coma or you're in a vegetative state. So the DNR can only put in place by a doctor. So we don't prepare DNRs. And it only relates to CPR and those types of procedures. So it's something that you would talk to your doctor about to get that done. The living will is something that attorneys prepare. And that's where you're the physician or APRN. Sometimes people will specify they just want a physician, has to certify that you have a terminal illness that will result in death without life support. Or two physicians conclude you are permanently unconscious. I've had clients who have revised that to say two physicians in consultation with my spouse. So, I mean, this is sort of the standard language. And we're talking here about things like breathing tubes, CPR, artificial nutrition, and hydration. Okay. Any questions on the healthcare? Oh, similarly, just getting back to because you had that good question before, you can name multiple healthcare representatives. So you can say, I name spouse, if you wish to do that. And then if my spouse can't act, again, you always want to have backups in place. And you can, name multiple people and you can say either any of them can act on my behalf. you know, one word of caution is that I find that sometimes people who are preparing powers of attorney in healthcare, they'll want to name all their children because they feel like one of them will feel slighted if they're not on there, right? And, you know, my word of caution to that is, you know, you're, particularly with the power of attorney, you know, you're giving that person very broad powers. And it's, you know, it's really, you really have to be focused on choosing someone who you can trust is going to really do what needs to get done. And sometimes people will say, well, I have one child who would be great at this, but they would never be able to be my healthcare representative because they could never make a healthcare decision in an emergency. So it's good just to be aware of those things and kind of honor what, you know, your particular situation is. Any questions on the healthcare? All right, so I'm going to move now to after death. And so we've passed the line there. So first, I want to talk a little bit about the last will and testament. So a couple of things wanted to point out is that so each state has its laws about how a power of attorney should be executed. So in Connecticut, it has to be a written document signed by a testator. Testator has to be 18 years or older and of sound mind, capable of reasoning and decision-making. It has to be signed by and attested to by 2 witnesses in the presence of the testator. And it has to have an attestation clause where the witnesses are saying that they're attesting to your being 18 years of older of sound mind, and that you're executing the document as your own free act and deed. So sometimes I have people say, well, what if I lived in a different state and my will was prepared somewhere else? So as long as that document was prepared in conforming with the laws of that state, then it's valid. It would get probated in Connecticut here under the laws of that state. So if there was a dispute of some kind, the laws of that state where it was created would govern, which can make things a little bit tricky because the probate courts here are, you know, obviously accustomed to Connecticut law, but it is valid, even though it wasn't created here. Who sees it? So the last will and testament, a couple of things I want to point out is that so your will, when your will gets submitted to the probate court, the will becomes a public document. So, you know, people can go in and request a copy of the will, and as well as the probate court filings. So for some people, that's more of an issue than others. The will can always be changed. So you can amend it by a codicil, what's called a codicil. So if you have a simple change, like a name change or something, typically someone will do a codicil, or sometimes the will get entirely changed, and you'll have a new one. Okay. So what could happen? So I did say that a will that's created in a different state is valid as long as it was properly executed in that state. But what if it's not? So we have this little scenario here where John decided he was going to, you know, I have clients who say, well, I don't really have a lot. So I'm just going to do my own will because I don't really have a lot of assets. But he didn't execute it properly because maybe he used an online program, which, you know, has wills from all different states, and he didn't get the appropriate number of signatures. And so what happened when he died, the probate court deemed the will invalid, which would mean that then the assets had to pass by the laws of intestacy. So not what John had intended. Okay, so laws of intestacy. So what happens if you don't have a will? Again, so sometimes people say, well, I don't really need a will. I don't have all that much. And that really isn't the driving factor, because if you die without a will, then the laws of intestacy, which are the statutes, intestacy statutes, are going to govern what happens with your assets at the time of your death. So here is an example, an illustration of how this might not work the way you might think or want. So Sue and Doug were happily married for 24 years and then Doug died suddenly. They didn't have any kids. He didn't have a will. So then Sue was upset to find out that she would in fact not get all of Doug's assets, that she would get the first 100,000 of Doug's estate, and then 75% of the remaining assets. And that Doug's parents would get the other 25% of the remaining assets. Similarly, let's say if Doug and Sue had children, Sue would have gotten the first 100,000, and then the kids would get 50% of the remaining assets, and then the spouse would get the other 50%. So everyone, I mean, most of my clients who are married want 100% of everything they have to go to spouse first, you know, if spouse is living. So this, as you can see, is not consistent with that. So this is one of the reasons why a will is so important, because you want to be the one to control and dictate what happens to your assets at the time of your death. The laws of intestacy probably are not going to be consistent with what your wishes are. You can also in a will make specific bequests of property. So if you have certain items that family heirlooms or just things that are particularly meaningful to some people, and you want to specify that in the will, that would make that, you know, legally binding that you wanted certain people to get those items. You can also, by having a will, you're specifying who you want to be your executor. The executor is the person who's in charge of the estate. And again, you want to, best practice would say, not only name one person, but also name a backup, you know, because people do their wills and they don't look at them again for 20 years. And the person that they may have named may no longer be around. So you also, for people who have children, this is the document where you would name your guardian. So if you have minor children at the time of your death, you can say who you would like to be guardian. So the executor, again, is the person who, oh, yes.
Why is it, is there any way around not having something come in to probate and look at your will?
Yes.
Yes.
And I will, can I put a pin in that? Because I'm going to get to it in a couple slides. So she asked, is there any way to protect? Well, there's no way to protect someone seeing your will. There is a way to not have a probate estate where they would have access to your will. And so that's using a trust, and I'm going to get to that in a couple of slides. So the executor is the person who's going to be handling the estate. This is the person, like I said before, if you've got, a lot of times I have people who have the same, they name the same power of attorney in the executor. Like I said, power of attorney, and the power ends at death. And then it's your executor is the person who's going to have the legal authority to manage your assets from that point on. In Connecticut, if you have a probate estate, or if you have probate assets less than $40,000, the state has what's called a small estate process, where you don't have to go through all the formalities of a full estate. And in that case, you wouldn't have an executor, you would have what's called a personal representative. Okay. So the executor, here's some things the person can do and can't do. So when your executor will have to secure assets after your death. So they're going to have to make sure house is secure, that accounts, financial institutions have been notified. They're going to be the one that deals with creditors. So if there's unpaid claims, your executor is they're going to present them to the executor, and the executor is going to be the one to determine whether or not the claim is valid and whether or not estate funds should be paid, should pay the claim. The executor is going to have to most likely open an estate account and then transfer your assets, your bank accounts into that estate account. The executor is responsible for making sure that the beneficiaries inherit your property in accordance with your wishes that you've set forth in your will, and that they have to comply with the probate court requirements. So they have no control over assets held in trust. So to just take a step back, your probate estate, so the estate, your will is going to control the assets in your probate estate. So sometimes I have clients who will say, well, what about my retirement accounts? Your retirement accounts are not going to pass under your will. Your retirements are going to pass by way of beneficiary designation, as long as you've in fact named a beneficiary. So you can technically have a will that leaves everything to your brother, and your beneficiary designations could name something else. And that's how those assets would pass. So the will is only going to have, it's only going to have control over assets that you own solely at the time of your death. So jointly owned assets, things like how, many people own their houses with a spouse, anything, or a bank account, anything that's jointly owned is going to pass to the survivor by operation of law. So it doesn't require any probate court intervention to legally transfer title. So that will not pass by way of under the will. And life insurance, if it has a beneficiary designation, will not pass under the will. So the executor has no control over these other what we call non-probate assets. They also are limited to the powers spelled out in the will. So sometimes if the will doesn't include things, an executor could have to go to the probate court and ask permission to do something. So all of this is set forth in the statutes, the probate process. So that being said, it's important when you're doing an estate plan, and this gets back to the point of it's more than just a document, is that when you're working with an attorney to put your plan together, you want to have conversations like, how are my assets titled? Because like I said, if it's jointly owned, it's going to pass to the joint owner, which in many cases might be fine. For example, in the case of a spouse, I have a lot of clients who come in and they say, well, my daughter is on my account with me, so we're joint owners. But then they may not realize that what's going to happen is that at their death, that daughter is going to now have all that, the money in that account. She is going to be the legal owner, which might be okay. Maybe it's a single, it's her only child. Maybe the family gets along just fine because the intent is that that child's going to divide everything up. That's what they all, that was what she had wanted. But it also could mean that your estate plan is not what you intended. So if you intend for everything to be distributed equally, that can compromise that, because now you have someone has full ownership of that asset. So it's an important thing to consider and to talk about with whoever's doing your plan with you. What I recommend as an alternative to the joint ownership is having a power of attorney. So instead of having someone named on your account with you, have your power of attorney added to the account, not as a legal owner, but as power of attorney. So, I mean, the main reason why people add their children on as joint owners is because they want them to be able to help them write checks, do things like that. And that's what your power of attorney can do. And that wouldn't jeopardize ownership of it. I also had a case where the son was going through a divorce, so he put his mother on the deed to his property. So he put it in his mother's name and somebody else's name. Never intended, she never lived there, so it was never intended to be hers. But then years later, she had to apply for Medicaid. Well, this asset's now in her name, and the state doesn't care that was the intent at the time, was to protect the asset from the divorcing spouse. So legal ownership has, certain implications that have to be really thought through. So it's important when you're reviewing your plan I always ask my clients, who is on, do you have beneficiary designated, and do you have contingents? Because that's also important. I had a situation where, and I see it a lot, where people will have spouse on as their primary beneficiary in their retirement, maybe they had minor children at the time and they never put them on, but they never went back and revisited it. I had a situation where a husband and wife died within a week of each other and they didn't have any contingents on. And what that meant is that everything had to then pay out to the estate, which had tax implications and just made the probate process more complicated. So it's a good idea to revisit these as part of your planning and on an ongoing basis going forward. So estate planning, so we touched upon this a little bit, but the people. So in addition to the documents and making sure that they're valid and they reflect your wishes, we have a lot of conversations with clients about, well, who should, you know, like you had asked, well, who can do this? Who should do it? Who should be my executor? Who should be my power of attorney? Do they have to be, you know, a financial whiz? You know, things like that, the questions that, and it's important that you don't just sort of choose defaults and just hope that everything goes well. Yes.
I'd like to add. Do you make a stipulation of how to pay an executor or a power of attorney? Because they can run into lots of work.
That's right. So the question was, what about compensating your executor or your power of attorney, or even your trustee if you have a trust? And so if you want assets to be used to compensate, then that should be stated in the document. And the standard, because people always ask, well, how much can they get? And the law is a little, you know, there's no specific in the statute, but what it says is reasonable, what's reasonable under the circumstances. So it's really about looking at what's customary that people are charging, what's involved. So if it's something complicated, like if someone's doing your taxes, you know, what does that person charge? Sometimes people do it on an hourly basis.
Okay.
But the court is going to, when you have a probate estate, the court is going to examine every expenditure from the estate. Because remember, there's a duty to the beneficiaries. So the executor is going to have to report everything that got paid out of the estate from the person's date of death forward. And that includes compensation. So there is, you know, that the court is going to look at that and make sure that someone's not abusing that. But you're right, it can be a lot of work. And so it is many times fair that people do get compensated. You know, sometimes it will be in the document, but people will waive it. You know, they won't actually do it.
That's what I said to my
Yes.
daughter. You should take a fee for doing it if you do it. And she
Right.
said, oh, I never would.
Right. But maybe doesn't anticipate the work either, right? Right. But yeah, a lot of children don't, but some people think that if someone is getting paid, that they'll take the job more seriously. I've heard people mention that. But okay. Any questions before I talk about wills and trusts, wills versus trusts? Okay. Oh, yes.
Why is it a good idea for me to put my children's name on the house? Or why should I not?
So that is kind of getting into the area of asset protection. So people sometimes will put their kids' names on the house, so that if they need to apply for Medicaid, that it won't be considered an asset. And so the most obvious reason why not to do that is because you're relinquishing control of that asset, right? Yes, because it's now legally theirs. And although your intent is to say, hold on to this for me, but it's really still mine, legally, it's in their names. And so what can also happen again is that when you have an asset in someone else's name, it's subject to whatever's happening in their lives. So if they're get a divorce, or if they get into a car accident and they get sued, you know, similar to my example about the person applying for Medicaid, their name's on the deed. So those are sort of the bigger risks.
I had worked for a bank at one time, and one customer came in and said his mother gave him the house,
Mhm.
but then he was, maybe she died, but then he got hit with very big taxes,
Oh, yeah. So,
because she just signed it over to him.
yeah, capital gain, if he sells it, when you give it to someone, they'll take it at your cost basis. So you can get hit with capital gains tax when you sell it. So that has to be done
Correct.
correctly.
Yeah.
Yes. Yeah. Yes.
The executive, you don't seconder or.
If there's no one to serve, then the court would have to appoint someone.
And were they sort of.
Yeah, so sometimes if there might be someone who steps forward to do it, like a relative. If not, attorneys, like we sometimes have to do that. Yes, yes. Mhm, mhm. Okay, so will versus trust. So I have a lot, this is a frequently asked question from clients. I've heard about my friend so-and-so has a trust. Do I need a trust? Or someone said I needed a trust. So I wanted to touch upon will versus trust and the benefits of each one of those. We talked a lot about wills already. So when we're talking about trust, we're talking about revocable trust. So revocable trust is a will substitute, essentially. It is going to control and dictate where your assets go at the time of your death, just like your will does. But the trust is think of it as sort of like a bucket. So you're creating this during your lifetime, and you can put assets, and you really should put assets into it. So now it's holding the assets. It's completely revocable, which means that you can change it. You can always, it's created by what's called a trust agreement. You can always change the agreement. You can amend it, you can revoke it. But then when you pass away, that trust becomes irrevocable. So then it becomes locked. And it can't be changed at that point. And then the assets get distributed in accordance with the trust terms. There's no probate court needed at that point, because now you have a trust that's irrevocable, that's its own entity. So think of it like a LLC or any other kind of entity. It's going to have its own tax ID number. And so it is not going to require the probate court to legally transfer title. The trustee is going to be in charge, and the trustee is going to distribute the assets in accordance with the terms of the trust. So these are the parties to the trust. The grantor is the person who makes the trust. It's also called a settler sometimes. The trustee is the person in charge of managing the trust, and the beneficiaries are the ones entitled to the assets. When you create this type of trust during your lifetime, you're going to be all three of these, because you're going to want to still be the one in charge. You're going to want to be the trustee, and you're going to be the one who's going to be accessing the assets and using them for your own benefit. You also can include spouse in that, and you can even say children. But there may be a time in your life where you are not the trustee because you can't serve, because you're incapacitated. And so trust can be a good way to achieve incapacity planning, because you're naming someone else to immediately step in and manage those assets if you can't do it. So for example, if I create a trust and I'm the trustee, but I also have my spouse as a co-trustee, or even as a backup, the trust owns the assets. If I'm incapacitated, and let's say if I have a financial account, they already have on file that my spouse is the other trustee or is the successor. And so there's more of a seamless transition, and that person can step right in. The trust document also typically has language that says, well, how can these assets be used if I do become incapacitated? Because I don't want them to just be able to be used on anybody for anybody's benefit. So I might say it can only be used for my benefit or my spouse. I could specify that it's okay to use it for my children. I could limit gifting. So I can say, it's okay to gift, but under the annual exclusion amount of 17,000. you can really craft it the way that you want it. Okay, so why create a living trust? One of the reasons is for what I explained, which is probate avoidance. So avoiding the probate process where you have to go through the statutory process in order for assets to get from the decedent to where they're intended to go, so to the beneficiaries. And the statutory process, just briefly, includes, filing the will, naming the executor, filing an inventory. So you have to tell the court exactly what the person owned at the time of death and what the value was. Also, there's a claims period. So there's a window of time, 150 days, where creditors can come forward with claims of unpaid debts, and nothing can happen during that time. So you may see that sometimes in the newspaper where it says, known creditors come forward, notify so-and-so who's the acting fiduciary. So that just has to be a waiting period. And then after that period of time, the executor has to file a financial accounting, has to report to the court. This is what has been paid out since the death of this person. And this is the proposed distribution at this point. So it can be a process that can last, depending on the assets, can last anywhere from 3 months to over a year. And it really depends on how complex the assets are. Is there property in another state? So if you live in Connecticut, but you own property in another state, you may have to have an estate here in Connecticut, and then what's called an ancillary estate, which is in that state where that second home or other property is located. So that can be another, complicating factor for people. So it's really about, and then it's also, the people component. So that can make the process be long if there's disputes among beneficiaries about how things were left or whether or not if someone was left out of the will. And so this kind of gets to the point about privacy. So when you die, all of your legal heirs have to be notified when you have a will. So they have to be notified that the will's been filed and that an estate's been opened. And this gives people the opportunity to come forward. So if you have disinherited a legal heir, they're going to be notified that the will's been filed. They're going to be able to get a copy of it. And so for some people, this is a concern. So with the trust, and this gets back to the question that you had in the back there, if that is a concern and you don't want people to have access to your will, a trust can be a good way to avoid it, because the trust is not a public document. It doesn't get filed. And the only people who have to be notified, which is a law that took effect in 2000, is the actual beneficiaries. So, which makes sense. So this was put in place to provide transparency, because when you have a trust, really the only people who are policing the trust and making sure the trustee is doing what they're supposed to do are the beneficiaries. They're keeping an eye out on the trustee. But if they don't know that they're a beneficiary and they haven't seen a copy of the trust, then they really are not in a good position to be able to do that. So the law now requires that beneficiaries, only when someone dies, so only when the trust becomes irrevocable. So if you create a revocable trust, the beneficiaries don't have to be notified, except when you die, they have to be notified that there's this trust, that they're a beneficiary of it, and that they are entitled to a copy if they request a copy. So that's how we can get the goal of privacy. So also another reason that people sometimes prefer a living trust is if you have a beneficiary and you have concerns about leaving assets outright to them. So let's say if it's a minor child, or it's someone who has substance abuse issues or spendthrift issues, or you're concerned about a potential divorce situation and you don't want a divorcing spouse to get assets, you can leave assets in trust. So you can say, I want everything to go in equal shares to my kids, but I want my sons to go in a trust for him. So that money would be available for his support, but it would be controlled by someone else. And it's not legally his. And there's different ways to craft the trust if creditor protection is an issue. I won't get into those specifics, but when you have, so a trust can be created for a beneficiary, both under a will. So I can have a will that says, I want to leave everything to my kids in equal shares, and I want it to be in a trust. That's what's called a testamentary trust. So it's a trust created under a will. When that happens, that trust, and it doesn't exist till I die. So when I die, the probate court has to then open the trust, acknowledge the trust, and then the probate court has ongoing jurisdiction over that trust. So the trustee has to periodically make accountings to the court. And in some cases that can be a good thing, right? If you have a trustee, let's say you've named a bank or someone to be the trustee and you want that oversight. You want someone looking out for the bank. You may be okay with that. A lot of people who set up trusts for their kids for the purposes of creditor protection, they have no concerns about the beneficiary. And maybe they have a trustee who they have no concerns about, and they don't want there to be that extra administrative burden of probate court oversight. And it also, in the case of a special needs trust, where you're creating a trust for a beneficiary who's on public benefits for their lifetime, there may not be a need for probate court oversight. And so the way to avoid it is to create a trust under a trust. Because like I said, a revocable trust does not have to go through probate. So many times that's a better kind of solution.
Question?
Yes.
Would there be a reason to have both a will and a revocable?
Yes, so good question. She said, is there a reason to have both? So typically, if you have a revocable trust, you're still going to have a will, but the will is going to be very different than your typical last will and testament. It's not going to have the same distribution provisions in it, because the purpose of that will is essentially to say that, remember I said that the only thing that passes under the will are solely owned assets. So it's basically what that will does is it says, if I die and I own anything in my name alone, I want that asset poured into my trust. So we typically will say, we'll name the trust as the beneficiary. So that's it's a very simple will. This is just making the point of that when so sometimes I have clients who come in and their estate plan is very simple. You know, they may just have, it might be a young couple with children, and they just really are focused on their guardian. You know, there are many lawyers who can do estate planning and do estate planning, but some have more expertise than others, just like anyone, right? So when you're dealing with issues having to do with estate tax or more complicated estate planning, then it's a really good idea. And Medicaid is asset protection. The rules are so complex and specific. You know, I have people who come into me with the trust created somewhere else and thinking that it's protecting a house, and it doesn't have the necessary provisions in it. So it's just kind of a reminder to be, you know, be kind of asking questions and make sure that the person has the expertise that they're looking for. So as a last, so I have clients who will say to me, okay, now what do I do with my documents? And what we say is that you want to store them in a waterproof, fireproof place, because the court will only accept a original will. It won't accept a copy. So it's important to be able to, specifically with the will, to have it kept. I have clients who have have had their wills stored with attorneys who are no longer there, and they say, well, how can I get them? A lot of times, an attorney, what they should do is they should transfer files over. We're actually required to, like if our office is going to close, we're required to notify clients whose wills that we have to say that we're closing and give them the opportunity to get them back. But if a client's moved, they may never get that notice. So then the statewide grievance committee is another place to contact for a will as well. So sometimes they know where wills can be found. People ask me, well, if I have a will, do wills get filed somewhere? Like, is there a place where wills get filed? And the answer is no. So you create a will and now it's yours. And it's really important to, number one, keep it somewhere safe, but also to communicate to whomever your executor is going to be and your power of attorney, where they can find it. Because I've had clients who haven't been able, their children who haven't been able to find their documents, and that's not a fun situation